Pradeep is a lawyer. He's an environmental lawyer with very well qualified, and he presently is at the Institute of Advanced Sustainability Studies in Potsdam, where he is looking quite closely at the law of the sea and is especially related to seabed mining, and he's had about 7 years of experience doing that. I really want him to talk to us because the international picture of developing a legal framework for this will, of course, affect the national jurisdictions, although in many ways, Pradeep, I see sometimes the national jurisdictions are ahead of the international. In some instances, they're non-existent compared to the international. So I'd like to ask Pradeep to go ahead with his talk to us, please.
Thanks, Bronwyn. Let me share my screen. Right, please let me know if you could see my screen.
Yes, we can.
Yes, I can.
Great, so thanks for the introduction and the invitation, Bronwyn. Always happy to speak about this topic that I've spent quite a few years on. And so today I'll be talking more about legal and regulatory aspects of seabed mining, and also, as Bronwyn mentioned, to sort of look at the international seabed, which is known as the area, and also at the same time, to look at seabed areas in areas within national jurisdiction. Right, so basically, as Bronwyn mentioned, we're sort of looking at 200 meters onwards, depths of 200 meters and onwards. And as we know, seabed mining can take place, both in areas within and beyond national jurisdiction. When we talk about mining beyond national jurisdiction, no particular country has any sovereignty or sovereign rights over the resources. So countries may only access the resources through the International Seabed Authority. Whereas within national jurisdiction, it's clear that coastal states have sovereign rights, and I'll come back to this later. So the entire basis for this is the UN Convention on the Law of the Sea, which Bronwyn already alluded to, UNCLOS, which we widely regard as the constitution for the oceans. At the moment, we have 167 member states that are parties to this convention. The convention applies both to areas within and beyond national jurisdiction. It also tells us the various maritime zones and what rights and obligations exist in those zones. And it's important to state that this convention is legally binding on all member states. So, it's something that you just cannot ignore. And another element to it is that member states are, of course, expected and required, rather, to give effect to the convention through domestic legislation, policies, and procedures. Now, I mentioned the Convention on the Law of the Sea. As you can see, it was adopted in 1982, but negotiations started in 1970s. And the topic of deep seabed mining first, came up in the 1960s as something that needs to be regulated. But what is important to note is that, in the 60s, in the 70s, we knew very, very little about the deep sea. In fact, we still know little about it, but back then it was really very little. And it was mostly thought to be a desert or where, there's no life in that area. And in fact, even when we were talking about regulating resources, hydrothermal vents were not even discovered or back then. They were only discovered in the 70s. So this is important to keep in mind. So I mentioned the maritime zones that UNCLOS sort of creates. So we have, up to the first 12 nautical miles, this is called the territorial sea. It's basically a sovereign territory of the country, of the coastal state. Beyond that is where sovereign rights come into place. So it's on the exclusive economic zone. It's also on the continental shelf. I should add here quickly that the continental shelf defined by the convention is different from the scientific understanding of what a continental shelf is. So basically under the convention, we're talking about the continental shelf, the rise and the slope as the continental shelf. Another more appropriate way to say it is the continental margin, I suppose, but this is the definition of the continental shelf. And this can extend to up to 200 nautical miles, and even in some cases, it can go beyond. For example, if you can show it's a natural prolongation of your continental shelf, it can actually go up to even 350 nautical miles. And everything beyond that is what is known as the international seabed or the area. So basically, just to sort of give you a quick look at the convention and what it's sort of, or the relevant sections of it. There are, quite a few sections, but the ones that we are particularly interested in when it comes to deep seabed mining is part 5 and part 6. So the EEZ and the continental shelf. So this is mainly for coastal state jurisdiction. And then there's part 11, the area or the international seabed, which is for areas beyond national jurisdiction, and part 12 of the convention, which is specifically on the protection and preservation of the marine environment. And part 12 applies both to areas within and beyond national jurisdiction. So Bronwyn sort of already put it out there, did the maps of it. So I basically just wanted to show you that the areas on the picture, on the image at the top is basically, you could see the EEZs of the world, and then the high seas, which are in light blue. And the image below is an indication of the extended continental shelf claims, which, as I was explaining earlier, could go up to 350 nautical miles. So basically, areas beyond that are areas that are beyond national jurisdiction. So what are the mineral resources of the deep seabed? There is quite a generic definition to it: all solid, liquid, or gaseous mineral resources. And today I will be focusing more on 3 types of resources that are both found within areas of national jurisdiction and beyond. So apart from what Bronwyn has covered, I'm looking at nodules, metallic sulfides, as well as cobalt-rich ferromanganese crust. And I guess the metal content that are available in these resources are sort of what is driving interest to actually go deep into the sea to get these metals. Just some pictures on how they look like, although I don't think the audience requires this, but just to get into that. And now, very quickly on the environmental concerns, I think Bronwyn has already covered it very nicely, and the slides from Lisa would also sort of address this, but I think this is important to set the stage because it doesn't really matter so much where deep seabed mining actually takes place, because as Bronwyn mentioned, the ocean is interconnected. So the deep sea gives us a lot of valuable services. We know from current understanding that there's going to be irreversible harm on human timescales, especially loss of biodiversity. Organisms would sort of be impacted. And in some cases, especially in seamounts, which are known to attract fishes and marine mammals, this would be highly impacted as well. And the activities would actually affect even far beyond where mining takes place, which can seriously affect the food web, as Bronwyn took us through. Discharge back into the ocean would also cause significant impacts. And cumulative impacts as well. This is something that is not appropriately taken into consideration, both in areas within and beyond national jurisdiction. This concept of strategic environmental assessment has really not found its way at the International Seabed Authority. And the last bullet point as well, regulatory control over environmental plans, environmental impact assessments, especially at the International Seabed Authority, these are almost non-existent. So focusing first on the international regulation of seabed mining, as mentioned, these are covered in part 11 of the convention, which also establishes this international organization known as the ISA. It declares the mineral resources that are located on the international seabed as the common heritage of mankind, which should be utilized for the benefit of mankind as a whole. And the ISA is given the mandate to develop rules, regulations, and procedures to enable this. I think the most important point here, there can be no mining unless you have a contract with the ISA. In terms of environmental protection, there's a very clear provision in the convention, Article 145, which requires the ISA to take necessary measures to ensure the effective protection of the marine environment from the harmful effects of mining activities. Now, in practice, there are a lot of concerns from an environmental governance perspective. And actually, if you look at the regulations that are currently being developed or that currently apply, there's actually very little room for the ISA to sort of intervene. So just a few points here. The decision-making processes at the ISA is sort of designed in a way to allow and to facilitate mining, basically to make it happen. There's no real possibility for the ISA to, for example, reject environmental plans that are submitted by contractors, including the EIAs as well. So they actually are not playing an active role. On a wider scale, there's no ISA-led strategic environmental assessments. What they do have is merely regional environmental plans, which admittedly are not entirely science-based, and to some extent these are catered to accommodate commercial interests in mining. One point to always remember is that it's actually difficult to impose changes once contracts are awarded. So even with new scientific knowledge and development, it's really hard to sort of undo contracts that have been awarded. Finally, I think this would also be covered by Lisa later on, by the slides from Lisa later on, is what do we actually mean by harmful effects that we actually need to avoid and minimize, and what do we actually mean by serious harm, which actually means levels of harm that we cannot accept and mining cannot happen or must stop if this threshold is sort of crossed. And these definitions have not yet been elaborated on. Now, coming to national jurisdiction, as I mentioned, Part 12 of the convention applies to both national and international areas. And all parts of UNCLOS must be interpreted in light of Part 12. Now, the preamble of the convention, which is quite interesting, that already in 1982 it was sort of stated that member states are conscious that the problems of ocean space are closely interrelated and need to be considered as a whole. And so this sort of underlines that the marine environment, the ocean, is interconnected. And I guess implicit within this, it's also something that we need to recognize, that is that it's difficult to actually contain harm when we talk about activities that happen in a liquid environment. And I think Bronwyn quite nicely alluded to that. So in the areas that I mentioned on the continental shelf, coastal states have sovereign rights over these resources, but sovereign rights here should not be understood as to imply that coastal states have complete or unquestionable discretion to use the resources there. It simply means that no other state or other actors can actually come and exploit these resources without the permission of the coastal state. It's also important to bear in mind that the duty to protect the marine environment always prevails. It's an obligation that states not only owe to each other, but they also owe this to the international community and to its own people. All member states are bound by the convention and must give effect to it via domestic legislation. And whatever domestic legislation that exists must be interpreted in the light of states' obligations under international law. And I just want to very quickly look at a recent decision in New Zealand, basically in relation to a case where seabed mining for iron sands was sort of rejected by the court. And just two paragraphs that I want to quote. The very opening paragraph, so paragraph 1, the Court of Appeal says that the convention provides that New Zealand has a duty to protect and preserve the marine environment. New Zealand has the sovereign rights to exploit the resources within its EEZ, pursuant to its own environmental policies and in accordance with that duty. So the EEZ Act and the Continental Shelf Act provides for the use of natural resources in a manner that has to be consistent with New Zealand's international law obligations, which include the duty to protect and preserve the marine environment. And then at a later paragraph, the court goes on to say that the international law framework is relevant to the interpretation of the EEZ Act. In particular, the EEZ Act must be interpreted to give effect to the Law of the Sea Convention, Convention on Biological Diversity, International Convention on the Prevention of Pollution from Ships, as well as the Convention on the Prevention of Marine Pollution from Dumping. So, these are all international obligations that sort of, come within domestic legislation and need to be given effect to. And administrations and regulators within national jurisdiction must always bear in mind these international obligations. Now, lastly, what sort of provisions under UNCLOS that we are talking about? I think I just picked out several ones to sort of, give you a flavor of this sort of obligations. But Article 192 says the obligation is there to protect and preserve the marine environment. Article 193, which as Bronwyn sort of alluded to, states clearly that states have the sovereign rights to exploit their resources, but this has to be pursuant to environmental policies, and what prevails is the duty to protect and preserve the marine environment. Article 194 also says that states shall either individually or jointly take measures to protect the marine environment. And 194.5 says that this should also be to protect rare or fragile ecosystems, as well as habitat of depleted, threatened, or endangered species and other forms of marine life. Article 206 basically talks about environmental impact assessments. And so it's always, on states, whenever activities within their jurisdiction are, reasonably, could reasonably cause pollution or significant or harmful changes to the marine environment, these effects must be assessed. And it's getting increasingly clear that deep seabed mining falls within this category. And in fact, the one international tribunal has sort of referred to this provision also when it talked about seabed mining. And finally, Article 208 basically says that coastal states must adopt laws and regulations to prevent, reduce, and control pollution of marine environment arising or in connection with seabed mining activities. So it's very clearly singles out seabed mining as a matter that sort of needs to be addressed and properly regulated. And these laws, regulations, and measures shall be no less effective than international rules, standards, as well as recommended practices and procedures. So it's quite clear from this that national seabed mining and international seabed mining, they need to be considered as a whole together and aligned with each other. And I have also put down some sort of further reading material, which I'm happy to share with you. And you could always email me if you have any further questions. So I'll stop here for now. Thank you.